was actually yours. That's mine. Nope, it's mine. This is People versus Jeffrey Beamer, 23S30597. He appears via video for the jail. Shears in the
Yeah, so we're gonna have to get him to put him in the room. When we get a chance, can you where you can break up.
Barnett, you said?
Yes, yes, Your Honor, David Barnett.
Okay.
I'm covering for Jill. So I just want to talk to Barnett.
So they'll have to put him in that other room.
Yeah.
Okay.
Okay, no.
Oh, I'm so sorry.
That's all right. So, can we get Mr. Barnett in front of a different camera so that I could get the attorney a minute to talk with him?
Will do.
Thank you. So if you just log in. I don't either.
350. 683.
Your Honor, when this attorney is done, may I have the same with my client? I've been waiting in jail for half an hour. They can't seem to get my client to visit me.
Okay, yeah. What's your client's name?
Crick, Kenneth Crick.
Okay, yeah, just remind me, please.
Thank you.
All right.
All right, so this is People versus Beamer. I provided recap information. Would you read the reading?
We will.
My understanding, he's going to plead guilty to count 1, the possession of meth. We'll dismiss all the subs, the HOA. There's a sentence agreement to 12 months with the Department of Corrections to 10 years and intermediate sanctions.
That is correct. And also, you said the subs, but count 2 as well would be dismissed.
All right, and then Mr. Beamer, is that your understanding of the agreement that Ms. Shears worked out on your behalf?
Yes.
Okay, raise your right hand, I'll have you sworn. Do you solemnly swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you can put your hand down. So the charge in count 1 is possession of methamphetamine, and that's a 10-year felony and or a $15,000 fine. You understand the nature of that charge?
Yes.
And then the maximum penalty of up to 15 years. I'm sorry, 10 years.
Yes.
All right. Do you understand that if you go forward with your plea, you won't have a clause?
I got a box. That one's green. We're all set.
So that era needs to go to a breakout room, District Court.
Okay.
Is that Ms. Smith?
Yeah. Just let me get rid of
The jail 2
DRF and Mr. Martin. He's not in it.
should be in.
And Moto
There he is.
just resigned 2. And then Miss Smith. There she is, Megan Smith. That would be 1. And where's the jails?
Montcalm County Jail 2.
Oh,
This guy down here, Jail 2 with Smith.
Yeah.
The guy in the bottom right is one of me.
all right.
And
All
this-
set.
That other one, that IBC,
Yeah.
we're not doing him today. He got on inadvertently. We adjourned that one. So you can get rid of that if you can.
Yeah, we can do that too. All right.
You sure we don't need-
Okay, so Mr. Beamer, back to you. So do you understand that if you go forward with this plea, you won't have a trial of any kind? Is that what you want to do, is waive that right to have a trial?
Yes.
All right. Waiving your right to have a trial means you'll waive all the rights that come along with a trial. I'll describe those for you now. It means that you're waiving the right to be presumed innocent of all these charges. It means you're waiving the right to confront any witnesses that would be called against you or to call your own witnesses. It means you're waiving the right to testify at a trial or not to say anything, and the trier of fact couldn't use that against you. Also means you're waiving the right to have the assistance of an attorney. You have Ms. Shear, and well, that was fast, Mr. Norton, and she could stay with you throughout a trial or even post-trial if need be. Are you waiving all those rights that would come along with a trial?
Yes.
All right. 2 other things you'll be waiving by waiving your right to have a trial. The first one is this: you'll be waiving the right to claim at a later date and time that it wasn't your choice to enter a plea. Do you understand that?
Yes.
You'll also be waiving the right to claim at a later date and time that there was some other promise or threat or inducement to you, except those we've already placed on the record. Do you understand that?
Yes.
All right. Even with your plea, you'll have a form of appellate review available to you, and it's called leave to appeal. With that, you could hire an attorney, but if you couldn't afford one, you could request one from the court. Do you understand that?
Yes.
All right. Let's talk about the charge then. Mr. Beamer, how do you plead to the charge of possession of methamphetamine?
Guilty.
Sir, the information says that that occurred on or about July 15th of this year in the township of Maple Valley and the county of Macomb. Is that the correct date and location?
Yes.
On that date and location, can you tell me in your own words what you did to be guilty of that crime?
Well, I didn't know it was in there, but they found a little bit of meth in the house when they went in, the state cops. They were chasing some kid who was out in the road and they went in the house and found it. So I'm
All
gonna
right,
take
so
the charge.
is this a house that you were living in?
Yeah. I own.
Okay, and where in the house did they find this methamphetamine?
And one of the bedrooms.
All right, and did it happen to be a bedroom that you would use?
Yes.
Okay. And then having found methamphetamine in a bedroom that you would use, do you concur for purposes of the plea that you knew or should have known about its presence in your bedroom?
I guess I should have known, but
I'm sure you want to help me out. I don't know that that's enough for a
I
factual
should
basis.
have known that it was in there since I go in there all the time.
If you give
I
me
should have known the
just,
meth was in there.
Sure.
I'm sorry, let me flip to the.
Like there's probably facts in there. Found it in his wallet.
Mr. Beamer, did you share this bedroom with anybody else or was it just yours?
I shared it.
Okay, and would you agree that it was indicated that this was found in a small cardboard box on a shelf on the west wall of that bedroom?
Yeah.
Okay.
Yes.
At one time, did you know that it was in there and had just forgotten about it?
Yeah.
Okay.
Yes.
So you would agree, sir, that the methamphetamine you knew was in this box, but it had been there for enough of a period of time that you may not have remembered when the police found it when they came into the bedroom you shared?
Yes.
Okay, and you would agree that that was methamphetamine that was in that box?
Yes.
Okay.
I think the court can take a factual basis with that. I'll just start. Anything else you'd like on the facts, Ms. Cross? Ms. Shear?
No, thank you.
Okay. And thank you, Ms. Shear. Mr. Beamer, back to you. Other than what we have talked about, has anybody else promised you or threatened you or done anything else to you to get you to enter this plea?
No.
And then other than Ms. Shear, that's her role as your attorney to suggest her thoughts about what sentencing might look like. But has anybody else said anything to you about what your sentence will be as a result of entering this plea?
No.
All right. Ms. Cross, you aware of any other promises, threats, or inducements to Mr. Beamer?
No, Your Honor.
Ms. Shear, how about you?
No, Your Honor.
And then Ms. Cross, do you believe the court's complied with the court rule for taking the plea?
Yes.
And Ms. Shear?
Yes, Your Honor.
All right, Mr. Beamer, do you have any questions about anything that we've covered now that we're almost completed this plea taking process?
No, I'm fine.
All right, last question I have, sir. Would you like the court to accept your plea?
Yes.
I will accept your plea. You did offer that plea freely, accurately, and voluntarily. Mr. Beamer, we'll need a pre-sentence report before sentencing. Somebody from probation will be over to talk with you and begin that process. Sentencing will be generally about 4 weeks from now, okay?
All right, thank you.
You're all set, thanks.
Yep, thank you.
Yes. Terrell.
Court does call the case of the people versus Remy Worcester.
Good afternoon,
The people.
good afternoon, Your Honor. Mitchell Nelson appearing on behalf of defendant Remy Worcester, who's present in the Zoom. Could you introduce yourself, Mr. Worcester?
Good afternoon, Your Honor. My name is Remy Worcester.
Okay, what are we doing?
Your Honor, we're requesting a preliminary examination in this matter.
All right. Preliminary examination will be set in person October 10th, 2023, 9 a.m. Second. Before Judge Fresh Hour.
Your Honor, may we address the question about bond that's important in this?
You want to address an issue you said, sir?
Yes, Your Honor.
Go ahead.
The parties, both the alleged victim and my client, are finalizing a divorce, which had as its final provision the transfer of the marital home on September 29th. The order of the court presently does not allow you to go to that home because Mrs. Dillard is living there at this point. We'd like the order to be changed. During the interim period, he's going to be moving into the home and obviously is not going to be in violation of the court's order. There also is a PPO issued by Mrs. Dillard that will have to be going to court to effect so that the change in the marital residence can be effected.
Okay, so he's going to be moving into the home that has a no contact on Fairmount. Is that correct?
Could I
Go
address
ahead.
that? I had the opportunity to speak with the victim's family law attorney this afternoon. I asked, the victim is still currently residing in the home. She has not vacated the home yet. I understand the plan is in effect that she will be gone by the due date in the judgment of divorce. I asked the family law attorney to email me confirmation that she is safely out of her home and into her undisclosed address. And once he emails me that confirmation, I will happily sign a stipulated order changing the no-go to. I'm not in agreement to changing it right now because she still lives in that home and she's legally present there. But I'm happy to sign a stipulated order as soon as I receive confirmation that the victim is safe and at the undisclosed address. I also would ask that, Your Honor, there will not be a no-go to provision that we're going to be replacing the current provision with, only because the defendant does not know the victim's new address. However, there are minor children involved. He may come to find out what her new address is inadvertently. And I would just ask that it be made very, very clear to the defendant that the no contact order with the victim, which is not being changed, would prevent him from going to anywhere she lives.
Your Honor, we object very strongly to these provisions. My client has effectively been denied visitation with his children since June of last year. This is a continuation of a process of harassment of my client. She came back after 2 months abroad. This incident happened the day she returned. She's got a PPO, and now she's saying she doesn't want him to have any contact for the foreseeable future with his children. This is in contravention of the agreement of the parties, the judgment of the divorce court. And
I'm not
she's
sure if
using
the
criminal
defense counsel misunderstood what I
as an
said.
end around of the agreement that parties entered in June of this year.
I'm not sure if defense counsel misunderstood what I said. There is a no contact order, Your Honor, preventing the defendant from having contact with the victim, his ex-wife.
Well, you also said he isn't going to have any contact with his children.
No, I didn't. No.
That is not what she indicated, counsel. I wouldn't have jurisdiction because that's not my purview in this case.
What if she doesn't move out on the 29th?
Well, then it would seem to me that she'd be in violation of a circuit court order or a family court order, because my understanding, as you've indicated to me, is that that's the order.
It is in both French and English, which we can't get a good copy of it, unfortunately.
Your Honor, I'm not bound by the judgment of divorce. My interest is protecting this victim. Certainly, if she violates a circuit court order, I'm providing her no legal advice. She's represented by counsel. That's not my interest here. My interest is protecting her. So, Your Honor, if defense counsel sends me a stipulated order deleting the no contact provision and I receive confirmation that she is out of the home and safely in her new address, I will happily sign that.
All right, preliminary examination is scheduled for what date, Your Honor?
October 10th, before Judge Fresh Hour.
So we have a 11-day period where potentially this could all be in limbo.
What are you arguing to me? I don't understand why it would be in limbo. You came to the court, hold on. You came to the court, said there's going to be a transfer of property on the 29th. Quite frankly, I'm a little bit worried about trying to change the order now when it's supposed to just happen tomorrow. What the prosecutor came up with is said, okay, once the alleged victim in this case is out of the premises, sign a stipulation, exactly what you asked this court to do goes into effect. So I don't understand the limbo part.
The problem is there's been a history of non-compliance with the whole divorce proceedings that of course the court isn't aware of, but my client has made me aware of, where she has not complied with previous court orders. And this is a position where she could continue putting him out.
Okay, but counsel, follow me here. If she's in violation of the family court order, you have your client has his remedies, right? So he could go to the family court, try to address all of that, and have the family court deal with it. But the cold-hearted reality of it is, this order, I'm not going to lift in any effect, so that if she violates it, that he can't go in there anyway, because he's going to be in violation of the no contact provision. So what you're telling me, quite frankly, and not just be blunt about it, doesn't make any sense.
Well, I beg to differ, Your Honor. The point is, I'm aware of the history of this lady avoiding court orders and abusing the court orders. And I'm trying to protect my client's interests. If we had
Okay, I understand you're trying to protect your client's interest. Let's say she follows what you believe to be the history. And you're right, I don't know the history. I didn't want to be a family court judge. So the problem becomes is that, let's say she moves out, she doesn't move out. What's your client do?
My client remains in a residence hotel.
Right. He can't go in until she moves out.
Well, so she's rewarded for disobeying a court order by punishing him.
How in the heck? I don't even follow your logic, counsel. Because it hasn't happened. I mean, it just hasn't happened. You want me to do something and it hasn't happened.
Your Honor, all I'm asking you is to put the date certain so that we have another enforceable position with this defendant.
Okay, here's the deal. No, here's the deal. Once she's out, then he can move in. That's what the circuit court or family court order projects will happen. The stipulation would be signed by the prosecutor, so that would happen. If all goes awry, all goes awry. It just does.
Well, but if we send a stipulation in Sunday, it could be another 3 days before he's able to get in the house.
I don't even understand that. What do you mean another 3 days?
Until the stipulation is signed and entered.
Okay. Apparently you haven't met Miss Hughes. If you send it to her, I will guarantee that it will be signed.
And if it's on a
Any
Sunday,
other predictions of like darkness and things not happening in the future that you want to make, that you want me to take care of and just did
no, Your
abuse you
Honor,
of?
that's quite enough. That's quite enough darkness. I have nothing further to add.
I didn't hear that last part.
I have nothing further to add.
Fantastic. So at this point, bond will continue. I anticipate the stipulation will be signed, and then you can get it to us by email, and we'll make sure that that's all taken care of.
We
Okay.
appreciate your prompt attention, Your Honor.
Thank you.
Thank you.
I'm happy to adjourn it to allow him to come in person.
Okay. I think he might have spoken with Mr. Ward. He might be okay. I just want to make sure.
Mr. Claybron,
Yes,
can you hear me okay?
Yes, I can.
Quiet, or is that just me?
I can hear you. I think,
Oh, good. Okay. Mr. Claybron, you had requested to come in person for whatever reason that we didn't.
I did request to come in person, but I at this point, I am okay with being sentenced today and over Zoom.
Okay. All right. Have you had enough time to speak to your attorney about the recommendation from the probation department and the pre-sentence report?
I mean, we've spoke about it. We have spoke about it. Yes.
Okay. Are you prepared to do sentencing then today, or do you need more time to speak to Mr. Bernstein?
I'm prepared to be sentenced today. I would like to speak on my own behalf, but I'm prepared to be sentenced today.
Okay, you get the last word then. So we'll do some other preliminary things first, and then whatever you have to share with me, you'll get that opportunity before sentence. As to the guidelines, counselors.
And Your Honor, the PD's office is on 23.
I'm sorry.
FH.
Sorry, did you get enough time to talk to the public defender as well on your
Yes,
547 FH case? Okay,
yes, he spoke with me this morning.
okay, good. Guidelines, 547 first.
No changes to the guidelines in 547, Your Honor.
Mr. Banner,
547, make sure I have 5 to 23. Yeah, I got 5 to 23.
okay, and 546. Mr. Drugas.
Me, Your Honor?
Oh, I'm sorry, Mr. Bernstein.
It's okay. I'm happy to be confused with Mr. Drugas from time to time.
Where is Mr. Drugas? He was just here.
Right there.
There he is. Oh, he's in the jury box, causing trouble. Juror number 11. Okay.
He's better looking than me, so I shouldn't usually be confused. But I do have a couple of guideline challenges, Your Honor.
Okay, let's hear him.
And they're all going to be the same challenge to these 3 OVs.
Okay.
To numbers 3, 9, and 10.
Okay.
The challenge is that these offense variables should only be limited to the sentencing offense under People v. McGraw. I think these variables are being scored as to the misdemeanor domestic assault or perhaps the resisting arrest case and not the possession of a firearm by a felon case, which is the sentencing offense. So I would be asking that those OVs not be scored.
Your Honor, and the people would say that it is my understanding that the criminal guideline score is scored for the entirety of the incident itself. So this DV is encapsulated in this incident. So therefore, anything that's related to the assaultive conduct, anything, I believe it's referred to him was 3, OV3 here, and that is in relation to, can be scored for the weapons offense, if in fact there is an injury, and in this case for OV3, it's predicated on the DV offense, my understanding.
Was there bodily injury?
No, there was not, Your Honor.
I'm going to get one second here as the begin exam.
Your Honor, the victim is here as well. If
Okay.
you can speak.
Stand by, Mr. Claybron, just a second.
Okay.
I'm gonna hear from the prosecutor, then we'll hear from your attorney, okay?
Okay, yes, ma'am.
Only thing that is shown is some swelling to the face, Your Honor.
What?
That caused by a firearm?
No, it would have been caused by the
Assault of some other kind.
yeah, the assault that occurred that accompanied this offense, as it was a 2-count case.
Not scoring OV3.
Then, Your Honor, the court,
Talk to me about that factually.
Your Honor, then there would be no basis to score OV9 at all, Your Honor, because if any of the assaultive conduct is not to be scored, all of those are related to his assaulting people in the home at the time. So if none of his assaults are to be scored, Your Honor, then.
So that gives us OV points of 10 instead of 35, which brings our level down to, what is this, a class E? 10 points. So that should be a 2. And a E2 is 12 to 24, reduction from 19 to 38. Do parties agree that I scored that correctly?
Yes, Your Honor.
Yes, Your Honor.
Mr. Claiborne, calm down now.
I'm sorry.
Like, you're in court, like,
sorry,
this
Miss
is
Slade. I'm
not
sorry.
like a sporting event.
I'm sorry.
Okay. Okay. Mr. Danner, as to the body of the report.
Your Honor, as in regards to the body of the report, Your Honor, the people have no objections and ask the court to just follow the recommendation of the probation, Your Honor.
And as to, is there restitution request?
Did not receive any restitution request in this case as of yet. Did you get anything?
Is there a victim impact statement?
And right now we're trying to get the victim logged in. It's my understanding that she victim did want to make there was a verbal impact statement to be requested to be made. And so yes.
Step aside, Your Honor, for that statement.
She's on Zoom. We're just waiting for her to unmute. Is it Miss Graham? Miss Graham, can you unmute, please? Miss Graham?
I gotta
Okay.
walk outside. Yeah, I'm walking outside.
Okay, we'll take a beat. It's okay.
Okay. Okay, I'm ready.
Okay, hi, Miss Graham. I'll give you a second. You don't need to rush. Okay, Miss Graham, this is an opportunity for you to share with me how you feel about this case.
I just wanted to say I'm not trying to exclude anything that he did or whatever. But I just really think that he needs to be like in the alcohol class or something like that. He's not a bad person. You know, my kids love him. My son continuously asks about him all the time. I just think that he may need a little help with his drinking. And I don't think that like prison time should be recommended because I just think that's a setback for somebody like him. And I just think he need a little help. That's all. Just so he can be like a part of my son's life and just healthy and alert.
I appreciate you taking the time to come to Zoom court today, and I'll take your feelings about the case to heart when I'm doing the sentencing. I appreciate you. You're welcome to stay on.
Okay, I will. Thank you too.
Thank you. So, a couple of questions before we go forward with your, for either of you. There's some pending cases in 14A. What's going on with those?
I don't know, Your Honor. Mr. Claiborne might know better. They might have been resolved
Okay.
since this was written, though.
Mr. Claiborne, can you tell me what's going on in your 14A cases?
Yes, the cases, well, it's a case now. I was originally, when I was arrested, I also had a warrant for another DV, and at that time it was a felonious assault and a felon in possession of a similar to this case. I went to preliminary examination August 1st, and the felony charges were dismissed without prejudice, and the prosecution remanded me to district court for a DV second offense in front of Judge Barr at 14A2, which I went to a pretrial hearing on August 15th, and they pushed my pretrial settlement conference back to October 11th, which will be about 2 weeks from now, well, less than 2 weeks from now, but that case was to be dropped then. It's just one count of DV now, second offense.
Is that case also alleged to be with Ms. Graham?
No, that was a different person.
Mr. Bernstein.
I should go first, Your Honor. Sorry, Mr. Mistake. I think what you're seeing here, Your Honor, with Mr. Claiborne, the storyline here is one of accountability. I would say kind of extreme accountability. We went to a preliminary exam, and he went there and he said, I prayed on it and I want to just enter a guilty plea straight up. And me and another attorney told him, that's not something that is really done. We could maybe talk to a prosecutor, talk to Judge Slay about this first. And he said, no, I messed up. I did wrong. I need to take responsibility for this. And, we told him, you don't have to do that, but he was very insistent, this is what I have to do. I was doing the wrong thing. I should take responsibility for it. I prayed on it and I've consulted my faith, and this is what I want to do. I would suggest to the court that accountability here for Mr. Claiborne equals insight, and that insight can give him the ability to do better and to show the court, to show Ms. Graham and his son that he can do better, Your Honor. I am heartened by it. Frankly, I was very impressed with his attitude that day and the kind of things that he was telling me in his position. You don't see that with everyone, just that, I did wrong. There's nothing to really else talk about. I'm going to plead guilty straight up. And that's that. I know he wants to say some words, so I'm not going to take too much thunder away from him, Your Honor. I'm hoping that the court takes into account that attitude in sentencing. I'm also hoping the court takes into account the change in guidelines. I think perhaps that could have changed probation's recommendations from what it was now. And hopefully the court would please consider a non-prison sentence for him.
Mr. Ward, did you have 2311, 111?
That was me, Your Honor.
You had the RNOs, that RNO?
Yes.
Okay, I'm just double. Okay, and the guidelines on that one were scored appropriately as the way the SIR reads.
I had no challenges to that, and I know that's not the controlling.
It is not, but I need to sign the SIR. And Mr. Danner, you were okay with the 7 to 23 on that one?
Yes, Your Honor.
Okay. Mr. Ward, as to the body of the report or recommendations?
Your Honor, the report has his jail credit as 82 days. In the ex-jail reflects 84 days. So that would be my only change.
In which case?
It looks.
Are you saying that the docket number or the days he was arrested, are those wrong? Is it really?
Well, he's been in since July 7 on all these cases. And extra as I calculated July 7th to today is 84 days.
Are they calculating good time within that? Like,
No,
no, that's the legit count.
Yeah, he's
I can get my day counter out.
Your Honor, there's no need for the day counter. I think it's just, if you just add those 2 extra days, because our report is stopping on the 25th. Today's the 28th, so of course he would have those extra days past the 25th.
They didn't put it through the sentencing day for whatever reason.
Monday, Thursday.
Okay, so 84.
Your Honor, I did meet with Mr. Claiborne this morning. I likewise reiterate Mr. Bernstein's observations of someone wanting to take accountability and wanting to address the issues that bring before this court and has in the past. Mr. Claiborne was on probation in the 15th district, and he was in the Accountable Choices program, which he says he was really enjoying and doing.
What, in the community?
Yes.
Mr. Claiborne, did you do accountable choices with Mr. Henderson or with Mr. Brown?
I was with Mr. Henderson, James Henderson.
Okay.
And he wasn't obviously my case, the Tether case predates that. And in reflection on that case, like all the other cases, it's a substance abuse issue. He put himself, the report indicates he was intoxicated at the time of the transfer. He thinks pretty well, Your Honor, and he's asking the court for an opportunity to do that. And
Mr. Ward, are you telling me that you believe his assaultive behavior and plethora of DV cases are as a result of alcohol?
well, I mean, I know that's, I only am on the Tether case, Your Honor. I haven't, I obviously.
You made the
heard-
statement. Are you sticking with it?
Yeah, well, that obviously was the Miss Grant's opinion as well, and that's Mr. Claiborne's opinion he expressed to me. He thinks he can do well if he can tackle this issue, Your Honor.
Would you agree that lots of people drink? Would you agree that lots of people have struggles with substances, alcohol included?
I do.
Would you agree that not everyone hurts intimate partners when they're drinking?
I do agree with that.
Okay. Mr. Bernstein, do you have anything further?
No, Your Honor, and I think I don't want to speak too much for Mr. Claiborne, but he told the court that he was going through accountable choices, and I think that is a great program where he is learning that this isn't just this isn't just alcohol. This is him, right? Like I think that's what the court's point is, and I know that this court definitely looks to see whether people are presenting with accountability, whether they are taking ownership over those actions. And I think Mr. Claiborne does understand and would express that, when he's committing these things, he's committing it, not an external factor. Of course, I think Mr. Ward's correct. I mean, there are demons there that are affecting him, and that's undeniable, and he needs help with that. But I mean, at the end of the day, Your Honor, he's coming before this court, taking ownership, taking that accountability, and he's hoping for a chance to continue proving that to this court.
Mr. Danner, as to the request, now that the guidelines are 12 to 24 or from probation, does the recommendation change at all?
Your Honor, in my mind, the recommendation ought not change. If the court wanted to shave off a couple months, I could understand that. I'm still looking at the body of the report and the body of what his totality is. That's what we look at, is what is his criminal history, how he conducted himself while on probation, while out in the community. He's already shown that classes will not help him. He can go to all the classes he wants to. He's gonna still put his hands on people. That's just already based on his kind of conduct. If we were to look at it and just say, give him a month for every crime he committed, that'd be over 31 months. That'd be over what he is. If we wanted to just kind of cut that and say you get a month for every felony, that'd still put him over a year, send him to prison for 14 months. the people belief is that if the court doesn't want to go with the full 24, I believe 20 months would be an appropriate middle ground.
Probation have the opportunity to talk to Mr. Henderson. Yes, no, not sure.
I don't know your.
Okay, I want to hear from him. So whether that be Mr. Ward, Mr. Bernstein, or probation, to get a release of information, and I want to hear from Mr. Henderson as to appropriateness for whether or not, you know, an opportunity for us to continue with growth, if that's possible, if their safety considerations are too much. I'm inclined to adjourn sentencing to 2 weeks. Mr. Claiborne, I'm not going to sentence you today. I do want to hear from Mr. Henderson, and I will take into considerations the victim impact statement that I heard today, but I also can't put aside that you have a voluminous criminal history, and most of it is assaultive. What I'm concerned about is that just addressing alcohol and not addressing the root cause as to why these assaultive crimes are happening is going to put only yourself and somebody else at risk in the future. And I'm unwilling to do that, but I do want to hear from the experts because I'm not an expert in that area, but I find Mr. Henderson to be very credible in that area. So I'm going to put this out. Do we be here in 2 weeks?
Please do the 19th, Your Honor.
Can we please do the 19th? Yes. Mr. Danner, can you please make arrangements for Mr. Claiborne to be here in person?
Yes, Your Honor, I will make the request with the jail.
Your Honor, did you want a statement from Mr. Henderson, or did you want Mr. Henderson to be present?
He doesn't need to be present. Just I'd like to hear somebody needs to reach out to him and then email, smoke signals, something. Okay, Mr. Claiborne, we'll see you back on the 19th, sir.
Thank you.
Thank you, Your Honor.
All right, thank you.
Thank you, Your Honor.
Thank you. Court does call the case. People versus Ahmed. Is it Enrinrich, right? Probably said that wrong.
Alex Chavalowski for the people.
Mr. Overwater.
Sorry, Your Honor, Ken Overwater, Assistant Public Defender on behalf of Mr. Ehrenreich.
State your name, sir. Mr. Ehrenreich.
Can you state your name for the judge?
Yes, my name is Amit Ehrenreich.
Okay.
At the same time, I do not have anyone representing me.
You don't?
No.
Okay, you
Your Honor,
don't want somebody representing you?
I will be representing myself, Your Honor, if I may.
Have you discussed that with Mr. Overwater of the Public Defender's Office?
I have not. I do not know Mr. Overwater.
Your Honor, if I may, I went to the jail yesterday to meet with Mr. Ehrenreich. One of the deputies brought him to the cell. He looked at me, and evidently he told the deputy he didn't know who I was, so he refused to meet with me. The deputy tried to encourage him to sit down and talk to me. He continued to refuse to do so, and then he left. Based on that, the information that I was given by the deputy I spoke with, as well as the allegations in the police report, I'm concerned that there may be an issue of competency. Obviously, I have not been able to speak to Mr. Ehrenreich, so I cannot verify that independently. What I was planning to ask for is for the court to admonish Mr. Ehrenreich to at least consider speaking to me and to adjourn the probable cause conference for that purpose. If he is resolute in his intention to represent himself and to refuse to speak with me, then I would leave it in the court's discretion.
If I might jump in, Judge. Torshio Feaster, Assistant Public Defender. Judge, I did represent Mr. Ehrenreich at a probation violation, a PPL violation about a week and a half ago. So he does know who I am. And at that time we spoke, he said he wanted to represent himself on the PPO violation, but he did want our office to help him on the new felony charge. So maybe he didn't speak to Mr. Overwater because he did not realize he's with our office. But I would, on behalf of Mr. Overwater, I think, ask for an adjournment and ask our client, please speak to him about this matter moving forward.
Mr. Ehrenreich?
Yes, Your
Did
Honor.
Did you hear Mr. Feaster?
I heard partially. One of the guards was speaking on his communication device, and I could not really hear what was going on.
Oh, okay. You had a hearing in circuit court on a PPO violation?
That is correct, Your Honor.
Okay. You remember the attorney that was representing you at that hearing, Mr. Feaster?
I do remember Mr. Feaster, and I believe the judge was Mr. Conlin, if I'm not mistaken.
That's right. Okay, that's right. So Mr. Feaster stepped in.
I cannot hear.
Can you hear me, sir?
Yes, yes.
Okay, Mr. Feaster just stepped in right now to let you know that Mr. Overwater, who you wouldn't speak to, that they're part of the same office. So you didn't know who Mr. Overwater was when he came to talk to you, but he and Mr. Feaster work in the same office. And I don't know if you were aware of that or not.
I understand what you're telling me, Your Honor. I understand. I was not aware of that.
Okay. So here's what. Go ahead.
At the same time, Your Honor, I would appreciate at this point representing myself.
Okay. Here's what
I will mention, Your Honor, that at the circuit court, I spoke very clearly, and Judge Conlin, for whatever reason, postponed the discussion, or he didn't want to hear what. I'm not exactly sure. Bless you. I'm not exactly sure what went on. I admitted to having gone to that street where that person lives.
No, Mr. Eckenwright, please don't say anything about the substance of the case. Anything you can be used against you. So please don't say anything like we discussed last time. Please wait and speak to Mr. Overwater and let him try to help you. You're facing a 5-year felony.
Mr. Ehrenreich, if you don't understand what happened in court, it might be because you need the assistance of an attorney.
All right, Mr. Ehrenreich, here's what I'm going to do. I'm not going to rule on your motion right at this moment to represent yourself. What I want you to do is talk to the public defender, and after talking with the public defender, you can make an informed decision as to whether or not that's what you want to do. Okay? So I'll hear you out on it. It's just that I'm not going to hear you out on it today. I want you to talk with them and make sure that you're clear on where you're headed with this. Because it sounds like there's a lot that you're dealing with in terms of the PPO violation, this case, and it could carry some severe consequences. And I just want to make sure that you talk to somebody before you make that decision. All right?
Your Honor, I appreciate what you're telling me, and I understand everything clearly. At the same time, I have done almost nothing. I do not understand why what I did not hurt a fly. I did not.
Okay. All right, Mr. Ehrenreich, I don't want you to say anything about the facts of the case. I will explain what happened and why you're in jail, what you're charged with. I'll explain everything to you if you will let me meet with you.
I do not wish to meet with Mr. Overwater, with all due respect to him.
Okay. All right. So, Mr. Ehrenreich, let me ask you this. You met with Mr. Feaster, correct?
I've had a video conference with him. I have not met with him in person.
Okay. All right. So I don't know, and I'm not going to interfere on who's going to meet with who, whose cases are assigned. The public defender's office now knows that. So it might be Mr. Feaster that you meet with, okay? But in any event, particularly given what you said, that you're not sure why you're there or anything else along those lines, I want you to meet with an attorney that can explain that to you. All right, and then you can make the decision as to whether or not you want to go forward and how. Okay.
Your Honor, I understand the situation completely.
Well, no, you don't, because you don't know what you did that has you where you are. And you just said that to me. So you don't understand it all. And I've got to make sure that you do. And one of the ways I can make sure that you do is to have you talk with somebody so they can at least explain why you're where you are right now. Okay, and that's so, Mr. Ehrenreich, I'm going to do that, and I'm going to do it to protect your rights. So I'm going to tell you that when they come down to talk with you, I need you to talk with them at least, okay? And then we'll come back, and then you can make your decision about what you want to do.
Your Honor, I respect everything that you say. At the same time, I do not wish to waste anybody's time. And from my point of view, I'm willing to proceed. I know exactly why I'm in jail. I know what I've done. I know what I did.
Well, you just told me a little while ago, Mr. Ehrenreich, you didn't know. And now you're telling me you know. That leads me to believe that I may have to order a competency on you. I don't want to do that. Okay? Mr. Ehrenreich, I'm going to implore you to speak with an attorney first. Because you're telling me one thing, then you're telling me something else. And that may lead me down a path that I don't know that you want to go to or go down.
It says the connection is unstable. I'm not exactly sure, Mr. Still hear you. Okay. Your Honor, can you hear me?
I can hear you.
Oh, all right. It just displayed the connection is unstable. I just want to be very clear on what I said in order to avoid any confusions or misunderstandings. I know wholeheartedly why I'm in jail. I know what I've done. I'm willing to hold myself accountable. I'm willing to hold myself accountable for what I've done. The thing I do not understand, and that's what I meant when I communicated that, I do not understand how what I've done is got to a point where if I feel felony, is being...
Mr. Ehrenreich, that's the problem. That's the problem. You need somebody to explain what, if you're saying you did something.
Yes.
And I don't want you to say what you did. If you said you did something, but you don't understand what the consequences of that are, that's a problem. And so I'm going to get an attorney to you. I'm going to ask you to speak with them so at least they can explain that to you. Then you can make your decision about whether you want them to help you and represent or whether or not you want to do it yourself. But I'm going, Mr. Ehrenreich, I'm done. That's what I'm going to do. It's up to you now to talk to the attorney so that you have as much information as you want. If you don't want to do that, you might want to tell me now so I can order a competency.
I rather represent myself. I rather not speak to an attorney. I do not feel that competency is needed. However, if Your Honor, if you would like to do that, it is up to you. You're the judge.
Oh, I am. So here's what I'm going to do. I'm going to order a competency a forensic evaluation, given what I've heard from the defendant on the record and what apparently is a confusion on a number of different levels. I'll set that competency hearing for,
You want to do 60 or 90?
60.
Tuesday, November 21st.
That'll be set for Tuesday, November 21st. November 21st, 2023. 9 a.m. Mr. Overwater, can you please prepare the orders for the court signature, please?
I will prepare that order. Thank you, Your Honor.
Thank you. Thank you, sir. Court calls the case.